Thank you. We now turn to item 19. It's a water matter that was on consent, but it's been moved to the general proceeding, and it'll be followed by a couple other water items. Let me present item 19. Colleagues, I'm presenting today for your consideration the resolution of a case involving serious allegations of wrongdoing by one of our regulated Class A water companies, Golden State Water. As documented in the proposed decision by Administrative Law Judge Doug Long, which is before you today for approval, this case began more than 4 years ago, in 2007. At that time, a whistleblower came forth to our legal division with information about an internal investigation at Golden State regarding improper contracting between the company and a particular contractor. The contracts involved large and expensive capital projects in the company's Region 1 service territory, which is in Northern California. What was troubling about these allegations was not only that the contracts were tainted with favoritism and larded with excessive costs, but also that the company apparently made a deliberate decision to not disclose these problems to the Commission, either in their periodic rate cases or otherwise. Our professional staff launched an aggressive and extensive investigation which largely confirmed the veracity of the original allegations. What came to light was a disturbing pattern of favoritism and other improper practices in Golden State's contracting for capital projects. This was a serious problem for the ratepayers because Golden State's rates for water service are set based on the costs incurred by the company. Typically, all the costs paid by the company, whether for capital products or for water supplies, or even for office equipment, are passed on to homeowners and other ratepayers in their water bills, as we know. Our job as a commission to make sure the costs are just and reasonable, not excessive. I want to particularly commend Maria Bondano of our legal division and Jim Booth of our Division of Water and Audits, sitting together there, who led this investigation. They diligently pursued the lead and found there was indeed significant problems with Golden State's contracting practices in Region 1. They also found the company had not been forthright in bringing these problems to the Commission's attention when they came to light during internal investigation. And all my colleagues have pointed out repeatedly that this is a fundamental responsibility of those that we regulate, to come forth to us and tell us the facts. They don't get to sweep it under the rug, or if they do, there's consequences. When these allegations came to my attention, I asked that the company participate along with our staff in an alternate dispute resolution process, which is overseen in this case by Administrative Law Judge Jessica Heck. I felt it was important to get to the bottom of these problems quickly and find solutions that would compensate ratepayers for any economic harm they may have suffered in the past. I also felt it was important to find ways to root out any bad practices by the company going forward, to make sure we had cured the problem and not merely sweep it under the carpet. Judge Heck did a wonderful job and was successful in getting the two sides, Golden State, Commission staff, to agree to what I think is a very favorable settlement for customers and ratepayers. The settlement I present to the Commission today accomplishes the goals I had in mind. As explained in greater detail in A.L.J. Long's decision, the remedies adopted here fall into three categories. 1, substantial rate reductions for customers. 2, a series of ongoing audits of Golden State's contracting practices. And 3, a $1 million fine which will be paid entirely by Golden State shareholders, not by ratepayers. Specific rate reductions for Golden State Water customers are as follows. 1, Golden State will pay $9.5 million in refunds to its customers as compensation for overcharges that our staff believe occurred in the past. 2, Golden State will reduce its rate base across its entire system by $2.5 million, which will further lower rates. And 3, Golden State will absorb, that is, not pass along to ratepayers, an amount of $500,000 currently booked into a memorandum account. In addition to these monetary remedies and the fine, Golden State also will be subject to a series of 3 annual audits on its contracting practices. These audits will be supervised by professional auditors in the Commission's Division of Water and Audits. This will help ensure that the problems our staff uncovered in the present investigation are not repeated or perpetuated by Golden State Water Company. Finally, A.L.J. Long, in his proposed decision, also orders Golden State in its next 2 general rate cases to provide sworn testimony documenting its efforts to improve internal controls. I endorse this additional requirement and applaud Judge Long for including it in the proposed decision. Colleagues, this case illustrates the importance we place on forthrightness and honesty by the utility companies that we regulate. I believe Golden State here was guilty of misconduct in the oversight of its contracting practices. This failure was compounded by Golden State's failure to disclose to our staff the results of its own internal investigation into this misconduct. I hope the outcome of this case will be a lesson for all utility companies in California. Do the right thing. And if you uncover evidence of wrongdoing, be forthright and bring the facts to our commission. We will not look kindly on a company that tries to cover up wrongdoing. I believe the $1 million fine imposed on Golden State may be the largest fine ever assessed a water company in the state of California, and it's certainly hefty given this for a company of Golden State's size. Excuse me. Finally, I also want to emphasize the constructive role played in this case by the administrative law judges division's alternative rate resolution program. Without the ADR process, this case would have dragged on for another year or perhaps longer through the adversarial hearing process. Thanks to ADR, we were able to get the case resolved much more quickly and on terms I think are very fair to Golden State's customers. So I ask for your support for this decision and move the item. Are there questions and comments? Commissioner Florio.
Yes, well, I asked for this item to be moved to the public agenda and was very pleased that President Peavey's office readily agreed, and I second everything he said. I'm going to skip a lot of my planned remarks because it's already been said. This was really an unacceptable situation, and it cannot happen again. And if it does, it will be dealt with harshly. I think the remedies are appropriate. I note that there was a whistleblower involved here who ultimately was terminated by the company, and I believe reached an out-of-court settlement as a result of that termination. We're going to be taking up whistleblower issues in the gas safety rulemaking, and that's something that I hope to focus on in the coming year. I also want to join President Peavey in thanking Maria Bondano, James Booth, and other staff in the Division of Water and Audits, including, and I'm going to get the pronunciation wrong, Coyote Kajipe, Joe Liu, Ravi Kumra, and Donna Wagner. This was a tremendous effort by our staff, and I think we've reached a just resolution here. Thank you.
Thank you. Commissioner Simon.
Yes. Or should I wait to hear Commissioner Farron? Excuse me. Okay. Okay. My mic is getting a lot of feedback here, but I'll try to, I don't know what's causing it, but in any case. Thank you, President Peavey, for bringing forth this significant settlement agreement with Golden State Water Company today, and I want to thank Commissioner Florio for taking it off the consent agenda. I'm pleased to support this settlement agreement, which requires Golden State Water Company to, and I will not go through what President Peavey already, I think, so clearly and eloquently articulated in terms of the fines and other remedies. But I'm glad that this matter was is on the regular agenda, because too often this commission has been criticized for not being vigilant enough, particularly with enforcement matters. This settlement could have easily been overlooked in our lengthy agenda today. This matter goes back to 2007 when I joined this commission, when a senior officer at Golden State brought to our attention the irregularities and transactions with an engineering firm engaged by the utility. Shortly thereafter, the legal division and our Division of Water and Audits began a 3-year robust investigation into allegations the Golden State Water Company did not exercise reasonable management oversight and failed to apply adequate internal controls over its procurement for plant improvements, primarily in one of its regions. The results of that investigation is a settlement and agreement before us today. In addition to the rate reductions, as President Peavey said, the Golden State will be paying the $1 million fine. I think that is a reasonable fine in light of the allegations that came forth. And at a maximum rate of $20,000 per occurrence as allowed by the PUC code, this equates to 50 serious violations. Going forward, to ensure that Golden State Water's improper practices are remedied and will not occur in other regions over the next 10 years, we've ordered Golden State to conduct 3 additional independent audits. I think it's going to be very important in terms of Golden State establishing best practices, particularly in their internal controls, and require Golden State's management to report on the management of their internal controls related to its practices. I want to recognize, of course, Attorney Maria Bondano, who's also been recognized by my fellow commissioners, and Joseph Liu, Donna Wagner, Jim Booth, and Ravi Kumra. This was a very, very ugly matter on a number of fronts. Based on the allegations and what was disclosed by the whistleblower, it even got to the point where there were certain racial references that were made that, in my opinion, were blatantly offensive, and I think not a good reflection on Golden State Water. I also want to say, sitting on the commission at the time, the difficulty that I had in obtaining a full briefing, and I know that it is often the position of the legal department that because the commission is in the role of somewhat of an appellate court, that certain things should not be we should not be privy to, and oftentimes matters go into sealed settlement discussions. And I understand that procedurally, but it was very difficult for me to obtain the level of briefing that I felt should have been brought to the attention of the sitting commissioners at the time that the whistleblower actions had taken place. But the good news is I believe the Golden State Water gets it. I think they're moving forward in a very effective and prudent fashion to remove what appeared to be a culture of deceit, a culture of less than transparent operations within their company. And in moving forward, I commend them for weeding out these issues. To somewhat reflect what my fellow commissioners have already stated to the utilities out there, it's really about what we used to call open kimono. You have to open it up and show it. This notion of you making the decisions, there's certain things that the commission should not be made privy to, will backfire on you if we become aware of it. The public is entitled to know those material elements that involve the obligations that ratepayers have provided to you to run your operations, and of course the services that you provide on demand. So with that stated, I'm glad that we're moving forward. I regret that this took 3 years. I think that is an inexcusable amount of time based on the allegations that were provided. And but with that said, I wish Golden State the best as you restructure around this decision. And I look forward to working with your offices in a multitude of areas. And let me point out that the water industry has been very aggressive in pursuing General Order 156 goals, and Golden State has been a part of that. To whatever extent there were racial allegations regarding an African American going to the board of directors, and as I understand it, it was at that time viewed as unacceptable. That has changed, and I think Golden State is an example of how a company can become not only socially responsible, but socially sensitive as well. And with that, I will support the settlement.
Thank you.
Yes, thank you very much. I wanted to support the remarks of all of my colleagues and just to underscore that it is important for the utility companies under our jurisdiction to do their jobs well, and it is even more important that when they discover that they have slipped up for whatever reason, that they come straight to us and get the matter straightened out. This commission and its rules, Rule 1, requires truthfulness and candor in dealings with this commission, and of course by extension with the public, and so that's very important. So I believe that this decision and what it has worked out underscores both to Golden State as well as to all utilities the need to clearly and explicitly demonstrate effective internal controls as a core corporate value, so that we're able to avoid other issues like this. I support the penalty in this case as appropriate, and again hope that this will encourage everyone to improve both their governance structure and to improve their candor in coming to us about violations or problems. So I wanted to conclude by thanking President Peavey for his leadership on this item, and to all of my colleagues, and special thanks to Administrative Law Judge Hecht, Administrative Law Judge Long, and to the Division of Water and Audits. Thank you.
Mr. Barron, any comments?
I'll just echo the comments of my colleagues that this is a serious matter, and I'm pleased to see that we have reached a settlement. I think 3 years is a long time for that to occur. I believe that in matters this egregious, justice should be swift, but I do think in this instance due diligence was followed, due process was followed, and that the judgment was appropriate.
Okay, very good. I move item 19. All those in favor, please indicate by saying aye. Aye. Right. I also want to thank our general counsel very much for his active role in this matter. Thank you very much, Frank. I think it did take a while, but it was a full investigation, and as Commissioner Farron said, that's part of due process to make sure you have a very, very strong case. It may have taken a little longer than we'd hoped, but